all elected officials, to some extent, have in mind how their conduct, how their decisions, their policy decisions will affect the next election. To go start saying now that, well, if you've got a part motive that's for your personal electoral gain, that that's somehow going to become an offense, it doesn't make any sense. And it's totally unworkable. And it can't be a basis for removing a president from office.
The Trump legal team this week rejecting House impeachment manager's claims that the president can be impeached because Democrats think his motives were corrupt. Let's bring in James Trusty. He's an attorney and former Justice Department prosecutor. Mr. Trusty, thanks for coming in again. I appreciate it.
Sure thing. Hey, Paul.
So the House arguments, the House manager's case is the Senate was obliged to call witnesses that the House refused to call and subpoena. What do you make of that argument?
Well, we know how it turned out. And the bottom line is it's not really set up to be a model of like a grand jury proceeding followed by a trial. And these are not really jurors. These are 100 judges sitting in review. So I don't think you can square the notion that there's a need for new witnesses, or at least you can't say that it's a foolproof winner at any point, because you're supposed to have a record, and the record has to close at some point. I think that was a very nice point that was being made by Deputy Counsel for the White House, Philbin, that you've got to, at some point, have a closed record. You can't have surprise after surprise by way of potential witness testimony.
Well, the House said, look, we couldn't call witnesses, subpoena them, because, in fact, the president had demanded total resistance, and therefore we couldn't, and he had claimed executive privilege, and we didn't want to fight that out legally in court because it would take too long. What do you, I mean, is that, and then so therefore we must impeach him for obstruction of Congress.
Right.
That I've never found a credible argument, but what about it? Is the president obliged to sort of say, you know, Congress can define what executive privilege is?
Well, look, here's the bottom line. You know, we don't like the thought of kind of blanket rejections coming from the White House. I will never cooperate.
Right.
But nobody forced his hand. And at the end of the day, if you're actually trying to have a subpoena and create an issue and fight over things like executive privilege, you've got to go formal. You've got to involve the judicial branch. And they specifically chose not to do that. They either didn't subpoena witnesses or even withdrew subpoenas saying, nope, we want to be done by Christmas. We can't have this fight. Well, I don't see how you can ever claim it's obstruction to either insist on a subpoena or litigate a subpoena. That's what half this town of lawyers does in Washington, D.C., is fight over process, motions to quash, assertions of privilege. We didn't have an opportunity for that in this case because the Democrats chose to keep it from going formal, to keep it from going to court. So I think it's kind of an unclean hand situation. If you do that, you have to live with the consequences of not really establishing any sort of obstruction.
Well, let's assume that the House had decided to subpoena John Bolton, and John Bolton's attorney, Chuck Cooper, has basically been waving his hand saying, please, subpoena, subpoena. But let's assume they did. What would have happened? Would they have lost on Bolton, maybe lost on Mick Mulvaney, or would they have won?
I think it would be a mixed bag. I mean, normally executive privilege is the type of thing that the congressmen try to work out behind closed doors. Maybe do a videotape closed deposition and agree to disagree or agree on certain portions that shouldn't be allowed to be part of the public record. But here, you'd be heading towards court, most likely. I think the interesting wrinkle to all this is Justice Roberts. Whether Roberts would have taken an active role in dealing with issues of executive privilege on the fly. And I actually think, based on how he answered the question about being a tie-breaking vote, that he probably wouldn't. Right. So once again, the Democrats are looking at a situation where if they tried to fight this fight, put Bolton on the stand, it's not his privilege to assert, it's the White House's. If that privilege is asserted, then you're back into litigation in the U.S. District Court in D.C., and you lose time.
But isn't it the distinction here is that the Chief Justice presides over impeachment as a presider. He's not there as an Article III judge litigating cases and controversies. The executive privilege claims are litigated outside in the District Court, the Appellate Court, and then ultimately the Supreme Court. Very different roles.
I think he would have stuck with that process if that's how it went out. You had this kind of siren song where people were saying, well, we've got a Chief Justice right here. He's a real smart guy. You know, all true. But I think he realized that the role is to be much more passive. Now, the wrinkle to all that is that he wouldn't ask that question of Senator Paul. And that was kind of a gatekeeper function. He was refusing to let the question about the whistleblower's identity even be read out loud. So that was a moment of activism that we didn't see with, say, Rehnquist during the Clinton impeachment.
Okay. The other thing, one of the other things that really puzzles me is the idea that that was with the House managers. They put together an article of impeachment on abuse of power, but they didn't list any specific crimes. They didn't say that there was a bribery violation. They didn't say it was an honest services fraud. They didn't say there was an extortion here. But then outside of the article itself, they claimed all of those things. So why didn't they include specific violations of law in the article?
I think the answer is because there were not specific violations of law. You know, and DOJ, non-political people at DOJ reached that conclusion early on. That's kind of forgotten or dismissed as being just part of a Praetorian Guard for Trump. But the reality is, you know, you heard early in this process Democrats on the House kind of stumbling around saying, well, maybe it's bribery, maybe it's extortion. And you just don't have it. You can't have a bribery or an extortion where the victim doesn't know he's being bribed or extorted. So I think they went vague, and that lowers the standard. That's the kind of thing that is easier to prove that he's a bad guy as opposed to he violated a federal statute. And the Republican team was all over that. And that's really why we're at this kind of summary judgment point where they're going to say, even if we accept these kind of half-baked proceedings from the House, it's not adding up sufficiently to establish an impeachable offense as a matter of law. And that lends itself to no witnesses and dismissal, just like many civil cases.
So overall, and briefly, do you think that all of this whole legal debate lowers the bar on future impeachments?
Well, the debate doesn't, but the articles do, would be my position. And frankly, that second article is a horrible precedent that if you resist a completely one-sided process administered by Adam Schiff, who was, you know, splitting his time announcing guilt before the investigation was done and then putting on witnesses with inadmissible hearsay for a normal trial. You know, if that is the basis for obstruction, then we've got a bad precedent and a real shift of power.
All right, James Trusty, thank you very much. Illuminating.